I wanted to put together a quick walkthrough of the USCIS policy memo that came out just a few short days ago on May 21st. If you have a pending green card case, if you're thinking about filing one, hopefully this is worth your time. I'll try to keep this practical, probably be a bit longer than the videos that I usually record, but we'll walk through, what the memo says, what it actually changes, and what stays the same. So this memo is about something called adjustment of status. And I'm going to go through what adjustment of status is very quickly. I think it helps to take a step back and understand what adjustment of status actually means. If you already know this, just fast forward or tune out for a minute. So in every green card case, there are two phases. There's the petition phase, and then there's the application phase. At the petition phase, this is where the client lays out how it is that he or she actually qualifies for a green card and under what specific section of the Immigration and Nationality Act. So this is where you demonstrate how you meet the criteria that are required by the particular green card category. So for example, one client might say, I married a US citizen, so I qualify for a green card. Another client might say, I won an Olympic medal in downhill skiing, therefore I qualify for a green card. In the case of EB5, the client says, I made an $800,000 investment. It's going to create 10 new full-time jobs in the US, therefore I qualify for a green card. So everybody does something different at the petition phase. At the application phase, everybody does the same thing. It's a standardized process. It's background checks, medical exam, biographic documentation to make sure that the client is something called admissible to the United States. And there are two ways to complete the application phase. One is to go to a US embassy or consulate abroad and complete the application phase there once your petition is approved. And the other, we can call that consular processing. The other way to complete the application phase is if you're already inside the US with a visa and you have a pending petition or a petition that's already been approved, assuming some other conditions, you can complete the application phase from inside the US. And that is called adjustment of status. So that is what this memo is talking about. It's talking about when USCIS is going to exercise its discretion in a positive way for people who are filing for adjustment of status from inside the US, completing the application phase from inside the US. And so the memo says that USCIS is going to treat adjustment of status as what they call an extraordinary relief or a matter of administrative grace. Administrative grace, I don't love the term, but it's something that we have to go with on the basis of this memo. So in practice, that means that officers from USCIS are being told to give more weight as a negative factor to the choice that the client made to apply from inside the US rather than saying, okay, I'll go through the normal process and I'll apply from a US consulate abroad. So that choice can now cut against the client when USCIS is looking at the application for adjustment of status as a whole and making sort of a discretionary determination as to whether to approve it. And a USCIS spokesperson went a step further and said, applicants whose cases demonstrate economic benefit or, serving some kind of national interest will continue on the adjustment path, whereas others will be asked to go abroad and complete the application phase through consular processing. So that's the headline. What does the memo not change? So there's some things worth being clear about. Law itself hasn't changed. Congress wrote the provisions for adjustment of status under Section 245 of the Immigration and Nationality Act. Those are still in place. The standard underlying foundational eligibility requirements haven't changed. If a client was eligible before May 21st, they're still eligible today. Certain protections that Congress wrote into the statute for specific categories are still there. There are kind of some forgiveness provisions for employment-based applicants under something called INA 245K. Concurrent filing rules for EB5 investors are still there. Those were written into the law through the RIA. But what has changed is how USCIS plans to exercise its discretion that the statute already gave to the agency. So they now have more latitude to scrutinize cases that it could have already scrutinized, but it doesn't have any new statutory authority to deny cases that already meet the eligibility requirements. And this isn't like a complete and total blanket prohibition on all adjustment of status filings. So if a client has a pending adjustment of status filing, case will continue to be, decided on its own merits. Eligibility was fixed by the facts at the time of filing and by the statute, but client can expect maybe a more searching discretionary review than they would have a few months ago. So practically that means, positive and negative equities that apply to your case probably deserve more attention than usual. Things like, immigration compliance, work authorization compliance, tax compliance, employment history, economic or national interest contribution that fits the particular situation. So for some clients, that means maybe being proactive and making a supplemental filing addressing those things. For other clients, we don't need to do anything. We'll just keep going and monitoring the case and seeing what happens. If a client is thinking about filing and they haven't filed yet, considering an adjustment of status application, analysis is probably a little different. Again, eligibility requirements remain the same, but the environment in which the application is going to be looked at overall is probably a bit more intense, especially in these coming months as USCIS actually implements the memo. But for most clients, especially our clients, if eligible for adjustment of status, that will remain the correct path. It's the process that Congress designated for people already in the country. They designed it for people already in the country. We will probably prepare those filings to address USCIS's discretionary considerations more proactively than we used to. So again, documenting contribution of economic nature to the United States, documenting any presence that would be in the national interest, compliance, etc. And honestly, for some clients, particularly who have a profile that kind of maps onto the economic benefit or national interest framework that the agency has kind of laid out, the case actually might be in a better position today under the new memo than it would have been under the old framework. Few things will change in how we work on client matters. We'll look at every pending file with the new memo in mind, identify any that might be on the edge that might, warrant supplemental submissions, additional documentation. Obviously, for new filings, review those with a much closer eye, see how the case fits within USCIS's discretionary preferences, and then obviously, track USCIS guidance, look at patterns as they develop. Memos, very recent, sort of operational framework is still forming. We'll know more in the coming months about how USCIS is actually applying it, which kind of cases are seeing different outcomes, and we'll share what we learn with you as it becomes meaningful. Again, just a few things that I want people to take away, which is that the law hasn't changed. Foundational eligibility requirements remain the same, but USCIS will now engage in a more kind of searching discretionary review for adjustment of status cases. And applicants whose files demonstrate clear economic or national interest equities are likely to face far fewer obstacles and be able to continue down that path that we've tracked. If you have questions about your specific situation, a client's situation, a family member's situation, or if something in your circumstances has changed since we last spoke, please be in touch. We're happy to take a look and let you know whether anything on your particular case, your client's particular case, your family member's particular case needs particular attention or change. Thanks so much for taking the time to watch this.